5 seconds to go. Start. The courts have to take a participatory role in a trial. They are not expected to be tape recorders to record whatever is being stated by the witnesses. Section 311 of the Code and Section 165 of the Evidence Act confer vast and wide powers on presiding officers of court to elicit all necessary materials by playing an active role in the evidence collecting process. They have to monitor the proceedings in aid of justice in a manner that something which is not relevant is not unnecessarily brought into record. Even if the prosecutor is remiss in some ways, it can control the proceedings effectively so that the ultimate objective, that is, truth, is arrived at. This becomes more necessary where the court has reasons to believe that the prosecuting agency or the prosecutor is not acting in the requisite manner. The court cannot afford to be wishfully or pretend to be blissfully ignorant or oblivious to such serious pitfalls or dereliction of duty on the part of the prosecuting agency. The prosecutor who does not act fairly and acts more like a counsel for the defense is a liability to the fair judicial system, and courts could not also play into the hands of such prosecuting agency showing indifference or adopting an attitude of total aloofness. The object underlying section 311 of the code is that there may not be failure of justice on account of mistake of either party in bringing the valuable evidence on record or leaving ambiguity in the statements of the witnesses examined from either side. The determinative factor is whether it is essential to the just decision of the case. The section is not limited only for the benefit of the accused, and it will not be an improper exercise of the powers of the court to summon a witness under this section merely because the evidence supports the case of the prosecution and not that of the accused. The section is a general section which applies to all proceedings, inquiries, and trials under the code and empowers the magistrate to issue summons to any witness at any stage of such proceedings, trial, or inquiry. In section 311, the significant expression that occurs is at any stage of any inquiry or trial or other proceeding under this code. It is, however, to be borne in mind that whereas the section confers a very wide power on the court on summoning witnesses, the discretion conferred is to be exercised judiciously, as the wider the power, the greater is the necessity for application of judicial mind. The court, while reiterating the principle enunciated in Mohanlal Soni Supra, stressed upon the wide ambit of section 311, which allows the power to be exercised at any stage, and held that the power of the court under section 165 of the Evidence Act is in a way complementary to its power under section 311 of the code. The section consists of two parts, that is, giving a discretion to the court to examine the witness at any stage, and the mandatory portion which compels the court to examine a witness if his evidence appears to be essential to the just decision of the court. Stop.